Hello and welcome to the Employee Handbook and HR podcast. I'm Arda Wildeboer, your host, here with Ryan Ellis, who's also a host. So I guess that makes me a co-host and Ryan a co-host too. I'm not really sure.
I think we should both call each other hosts, and then we can fight over it later.
Well, maybe we need to talk to a recruiter or something like that to find out exactly what our job is.
I'm taking that for my resume, and I challenge you to a host duel for the title.
Yeah, no, definitely. We gotta fight to the death or something like that.
Yeah.
That was like when I found out at the place where I buy my hair products that there were two other people named Arda who were in their system, because I was like, she's like, "What's your name?" I'm like, "Arda." She's like, "Last name?" I'm like, "What do you mean? How many Ardas do you have?" She's like, "3." What the hell?
Oh my God, that's fun. I would have bet a lot of money that there was not a lot of artists shopping for hair
Oh,
products.
same. My wife talked me out of standing in front of the store with a sword to when the other artists came, so we could fight to the death. But anyway, welcome back to the Ryan Coughs Awkwardly podcast.
I'm going to try to press my cough button, and I'm also going to try to not say the word and that one doesn't count.
Or, I keep doing that as well. There's a lot of pauses. We notice these things ourselves and are very sorry for all the things that are annoying that we do. We're not professionals at this. Oh, there we go. I just said again.
Well, you would think that talking about it would make us less self-conscious, but you're wrong. It makes us more self-conscious.
Exactly. And now we've gone, I don't know how many minutes without even getting to anything. But what we want to start out today with is a huge inaugural clashing of the Titans event, where an immovable object meets an unstoppable force, and we're merging our two segments.
Wait, which one am I?
I don't know. Just pick one. You could pick one, or we could flip a coin.
We'll flip a coin.
I think I weigh more, so I'll be the immovable force, just by default. But we are combining our famous segments, which Ryan's segment is called Billable Hours, and mine is called Would You Take the Case, to talk about a Reddit post that I found while I was perusing the internet for stuff to talk about. And this is something that comes up a lot regarding the topic of favoritism at work. This is a huge topic. I hear a lot as a plaintiff's attorney, and I think Ryan, this is a problem that you probably deal with as well.
All the time.
And it's a huge problem within companies that they have to solve, because these favoritism discussions are usually a precursor to lawsuits. And so I want to go ahead and let's see, we're going to read a little bit from this post. It's really quick. So the post was titled Frustrated, and here's the contents. What do you do when your direct boss has favorites and doesn't care about showing it? I feel like I work harder than the favorites, quote, yet I can never get a break. She, parentheses, the boss, takes opportunities from me and gives them to her favorite, quote, I'll call her Julie, or parentheses, sorry, I'll call her Julie, just so that they shine brighter. I love the company and would hate to leave, but I just can't handle the unfairness anymore. It really hurts, and I'm very depressed about it. I should add that my boss is the HR lead. I'm a colored person, their words, not mine, and not American. And sometimes I think I'm being treated this way because of that, although I hate that thought. What would you do? Thanks in advance.
That was a roller coaster for me of emotions as a defense attorney, or in my role as a defense attorney, because I thought I have a very funny, well, I know I have a very funny response for the first most of that. And then when I said, dang it. And then it goes to the part where my boss is the HR lead, and then I'm a colored person and not American. And sometimes I think I'm being treated because of that. And that's where it gets serious and bad for the employer in my comments. But just want to give a precursor to where I'm going, a preface, a foreshadowing, prophetic speech to where I will be in a few minutes. But Arda, please kick us off.
Yeah, I think that's a really good idea to break it down into different parts, because the first part where they're talking about how the boss has favorites and there's favorites in the office is something that I hear all the time. People come in and say the boss has somebody that they always hang out with and have lunch with, and they give me harder work, or they always tell me to hurry up, and they're always looking over my shoulder and things like that. And then, of course, the real kind of elephant in the room is when they toss in at the end, I'm a colored person and not American, and sometimes I think I'm being treated this way because of that. That is something that, as a plaintiff's attorney, if somebody comes into your office and tells you that, you sit up straight and you start wanting to hear their story and start wanting to get a lot of details and facts, because that's something that could be very lucrative for a plaintiff and very damaging to an employer, and you can end up as an employer mired in litigation on something like this for a long time.
Yeah.
So Ryan, do you want to address a little bit about just the favorites aspect, and whether, I mean, is it legal to have favorites if you're a supervisor?
Yeah. So my first initial response to this would be very antagonistic and be like, well, you're telling me that this person doesn't want his or her coworker to get favorable opportunities because that coworker potentially is just doing their job better. Now, we don't have enough facts here to see if there's any basis for favoritism, or if there's any reason why this person, whether legally or illegally, is being given a different treatment or short shrift at the job. We also don't know much about their employment and all that other stuff. But my first response is, why are you complaining to me? Or to the HR person, if they ask me this question, why is this person complaining, or why do we get this complaint? In quick answer, no, it's not illegal to have favorites, or unlawful or against any policy, unless there's some similar to nepotism policy in the handbook, which I don't usually see. I haven't seen in a while. But I would say it does become an issue when if assignments are given an opportunity, if all the opportunities are going from the boss to ARDA, there's going to be a problem. So just vague terms or vague facts we have here. No, it's not illegal to have favorites, especially given that that's work, right? I mean, I worked at big companies where I've had people that I like to talk to and people I didn't like to talk to. That's just life and that's work. I know I'm speaking a lot on this, but I had to tell my kids the other day, because every time we do something that they don't like, they say it's not fair. Or every time one kid gets a donut, the other kid gets a donut, even though they're similarly sized donuts, one has sprinkles, one doesn't, it's not fair. And trying to get across to a 4 and a 6-year-old, or anything really, but this specifically, that life is not fair, that sometimes, the people that work harder get more opportunities, the people that, sometimes luck is involved, but life is not fair. You're not going to go through, not everybody drives the same, whatever color vehicle, live in the same house, in the same neighborhood, on the same street, with the same income. That would be, equality and fair, and I guess communism, but nothing is to that level. So here, again, with all the facts we have, let's just assume the worst on my perspective. So assume this person just complaining about nothing. Then essentially the response from HR is, look, life is not fair. Get over it. Focus on your work. And if you have a personal problem with the individual, we can address that. But if you're just seeing these things from a third-party perspective and you're just jealous of it, get over it.
Well, I agree with everything you're saying. I just think that way of dealing with people, especially with younger people, and the expectations their generation has on how they're supposed to be treated at work, and how people treat each other, just generally interpersonal relations. I think you have to slow down a little bit, and validate how they're feeling, and kind of ask how they're feeling, and kind of act to address what's going on. I think if it's appropriate, yeah, you shut it down, depending on the circumstances, but also depending on the circumstances, try to be a little bit more empathetic, because of something that we talked about in earlier podcasts. The wrongful termination lawsuits and harassment and discrimination lawsuits are driven by emotion. People who are suing for those types of things are people who feel like they have not had their complaints or concerns validated, who feel like they have not been given a fair chance to explain if they're being fired or disciplined. So I think that's a very important thing that we have to talk about, just in the way that you talk to these employees when they bring up subjects like this.
Well, it's weird, because it sounds like we're on the same page with how to deal with the issue, at least at the stage early on of
the first stage. Yeah.
Which again is, I think, patently ridiculous. And I'm not a fan. I mean, I've been in the mire. I'm going to try to use big and complicated words, Arda, to try to be like
4 letters, mire.
Well, no, but I don't even know if I'm saying it right. I'm trying to be in the trenches of this employee. Or, I mean, we all grew up. I mean, I'm going to say we all, as in the people who had jobs. We all grew up having jobs, working for, I worked for a hotel chain and a restaurant. I worked for a bar and grill. I worked for a car detailing shop. I mean, I have a long history of random jobs I was growing up, as a kid. and we've all had, you know, personal experiences, and we all have different ways of dealing with our conflicts and issues. But I think me as an adult, I'm speaking for myself personally, and I know a lot of people that I know in, you know, in any job these days that are out of their 20s, essentially, like, you go to work and do a job. You don't go to work to have fun. And I'm going to quote my dad, who says, if work was fun, they would call it fun. But it's not. They call it work because you go and you work. Yes, people enjoy their job. I enjoy my job. Like, all of this stuff is there, but it's not fun. You're not there to have fun, especially as an employee. You're there to do a job and to leave. Can you make it enjoyable? Yes. Can you make it bearable? Yes. Are you having fun? Sometimes. Maybe you love your job, and that's great. But this person in this example does not sound like they love their job, because they're focusing and there's a point to this, I promise, that they're focusing their attention to other people, what other people are getting, what other people are doing, as opposed to doing their job. Again, I'm going to assume the best situation for the employer here in my discussion, which is this employee maybe isn't performing well. And maybe this employee is spending an hour a day looking around the office, trying to find out who's doing what to get dirt on people, or not focusing on the job, or just delaying whatever. Maybe their performance isn't well. Maybe, and again, I don't know if this is the reason, but maybe not being from America, there's a different work culture from wherever this person is. And that's fine. But again, to sit there and complain about things and not try to take action personally to fix the situation, I think is a big misstep. That's gone on a lot here.
And I think here, understanding the way that different generations, I mean, first of all, I think it's stupid to split people up into generations. It doesn't really make sense. But anyway, younger people, I think, have a very different idea of what work is supposed to be like than older people. I mean, we're kind of born in the early 80s, and a lot of your expectations about work and what life is going to be like is born out through watching media and TV and things like that. And everybody kind of expected around our age for work to be difficult, for your boss to yell at you, for you have to earn your place and things like that. So getting yelled at and things like that was not something that was foreign in terms of expectations for what work is like for a lot of people. And it's changed a lot. And that's one of those things, is HR being in charge of culture or driving culture in a company has to be aware of. This balancing of legally, what is your exposure here, and then as a person, how do you handle this? Because legally, if you feel like you don't have any legal exposure, maybe you just want to tell this person to fuck off and leave you alone. But if you are worried you have legal exposure, you might be a lot nicer. But I think because of the way that decisions to sue companies by plaintiffs, by ex-employees is very much emotionally driven, you have to be very aware of the emotions that are causing this person to bring up this problem or feel like this.
Yeah, and just to kind of highlight what you just said, that is, you might, as HR professionals or legal professionals, want to tell them to fuck off, or hey, you're blowing us out of proportion, get out of my office. Two things to focus on this first part of this example, which is one, of course, you would never say it to that person that way. We know that. We're speaking, very candidly about how people think about these issues sometimes. But two is that we have to take into account that this person is the HR lead. So, I mean, if you're going to go to complain to HR in this situation, if that's your boss, you're not going to complain to your boss, right? So you look to a policy to see who to report to, if your boss or your direct report is someone who's causing these issues, or just go above them. So taking it back to like a professional standpoint, what I would do in addressing this first part, although I said how I would do it in one or two sentences using a couple swear words or choice words, we would inform the HR person or the person that we acknowledge the issue, that doing so we see is affecting his morale and could affect the team morale, overall culture of the company, and his productivity, or her. I don't know if it's a he or she, or however they identify, that's fine. And that we would tell them essentially in telling them that we don't believe there's an issue here, or that we'll look into it, or we're conducting an investigation or whatever, depending on how bad it was, that we're doing so to not only address the concerns, but to make sure we're promoting a fair and inclusive workplace and how important that is. And then that essentially we're there to address those concerns and to help. Now, again, I think a very nice letter with one or two paragraphs and possibly a discussion will rid yourself of this problem. And to show that you're being empathetic to this person, which addresses the previous concerns we talked about, which is these employees just sometimes want to be heard and felt that their complaints are valid, or at least validated in some certain way, so they don't just sit there and stew.
And one thing that people have to keep in mind is that once these complaints go up the chain, it's like playing a game of telephone. The message will get lost the further it goes up the chain, and this person is just going to be looked at as an annoyance. Their personhood, it kind of gets lost as HR takes it up to a C-suite person. Maybe it goes up to general counsel or whatever it is. So I think if this person were to come in my office just talking about favoritism, I would tell them you really don't have much of a case here. If you don't like the environment, I would suggest that you look for another job or find a way to manage your feelings and manage your relationship with your boss. But again, another thing that I would tell them to do is put it in writing and send them a letter, because as an employee, if you complain, a lot of times you have a target on your back. And so if you write a letter describing the things that you're afraid of, or that you're dealing with, afraid of being retaliated against, I should say, and being fired for complaining, they'll make up something. Oh, you're tardy one day, you're fired. I would write a letter if I was the employee to HR and kind of explain, and then let them take it from there. Because that's also going to protect you. And if you're a company where an employee writes a letter like that to you, just know that they've probably retained an attorney, or at least gotten some advice from an attorney about this.
Yeah, no, that's a very good point. I think there's absolutely a reason for your side, or the plaintiff side, employee side, however you want to address it, to put it in writing, document it, make sure that there's an understanding that this complaint was made. Because as we will get into in a few minutes, the second half of this example, if the complaint or this issue leads to a lawsuit or any form of arbitration or other litigation, that's going to help the employee, and obviously be detrimental to the employer depending on what they do. Now, in addition to what I said earlier, depending on the facts, of course, actually, this is a good time to put in our caveat and our little asterisk: not legal advice, entertainment purposes only. We're not your attorneys. We'd love to consult with you if you're in one of our jurisdictions: California, Nevada, Texas, Michigan, I'm sure some others throughout our firm. But we just want to make sure you know that. Again, give the standard one every time. We're not financial advisors. We don't offer financial advice. Do not invest in stocks because of what we're talking about here. It's all for fun.
Advice either.
No tax advice. Trying to think what else I have in my engagement letter. Anyway, so going back to
pay your taxes. That's our one bit of tax advice, is to pay your taxes.
Yes. So going back to what the company should do. Obviously, address the concerns. Depending on the level of severity, you want to make sure you give it enough consideration to avoid the "you didn't investigate" issue. Again, just on the fact that there's favoritism, depending on how bad it is, again, there could be an issue where you have to address with the HR manager, HR lead, that they can't do this anymore. Maybe note to file. I would assume there's not going to be a PIP in place, because it seems a little excessive for this. But maybe a good middle ground is, with all of the e-learning available today to employers through not only HR services, online third-party services, but through insurance carriers, that maybe offer the HR lead training and awareness program, something to talk about how to avoid favoritism, but still maintain your friendships and personal relationships in the workplace. And then report whatever you do back to the employee. Say, hey, we told you all this stuff in the first place. After we investigate, we thank you for the complaint. Then follow up with, we investigated, we looked into it, we did whatever. It won't happen again. We're striving to do the best, and we did X, Y, Z. I would think that an employee who's made these comments or complaints to HR or to a supervisor or to a C-suite or whoever that would listen, given that it was an HR lead here that did these things, receiving a confirmation that the complaint was addressed, along with maybe training or a note to file being done, I think that it would satisfy a lot of concerns and avoid this being an issue going forward. Again, not saying they won't sue later, but who knows?
Yeah. All you can do is mitigate that. That's one thing that as an HR person, as general counsel, as C-suite person, you have to live with, is that you're going to get sued. It's going to happen. Sometimes there's nothing you can do. Every company, and no matter how many attorneys they have, no matter how many HR people they have on staff, no matter how good their general counsel is, how much they want to remain compliant, there's a chance that you're going to get sued, and there's nothing you can do about it. And so you just have to conduct your business and set up your business in a way to mitigate the consequences of being sued, which just means paying out less money when you do get sued.
Yep, agreed.
I want to add a few more facts from the original poster here, and we're going to do that in segment 2, because we're coming up on almost 20 minutes. I think probably a little less, but we'll be right back. And we are back. We just want to give a shout out to our sponsors, Law Office of Arda Wildeboer and Law Office of Ryan Ellis, who have very generously sponsored this podcast by paying for our yearly Zoom subscription, where we get to go over 40 minutes and not get not get cut off at that 40 minutes and then awkwardly have to explain to the other person that you didn't pay the $120 a year for your Zoom subscription.
Well, those sponsors sound amazing.
They're the best. Let me tell you, the best. Law Office of Arda Wildeboer and Ryan Ellis Law Corporation, two of the greatest sponsors that any podcast could have. So again, Law Office of Arda Wildeboer and Ryan Ellis Law, the best sponsors ever. We don't know where they came from and who they are, but they're awesome. So anyway, end of commercial. I want to read a few more facts from the original poster on the situation we're talking about in segment 1. In response to a question from a commenter talking about is it possible that Julie, the other employee, the favorite, gets work because she asked for it and does a good job, which was what Ryan was mentioning. This is what the person has said. I have responsibilities and always go above and beyond. I ask to be a part of different projects, which I complete successfully. I work from 8 a.m. to 6:30 p.m. while Julie comes and goes as she pleases. I know for certain that she doesn't do more than me. And the latest that happened was that the boss took a project that I led that turned out very successful and gave it to Julie with zero explanations to me. Also, this favoritism from the boss is not only towards me. Another person from the HR department left because of it. It's very frustrating and depressing. I will talk to the boss the day I quit and make sure she knows why I'm leaving.
Wow, that's not good.
It's kind of loaded. I mean, if I'm a general counsel or outside counsel or HR person, hearing the day I quit makes me feel a lot better in the sense that you're not likely to get hit with a wrongful termination because they quit. So, I mean, that's very promising, I guess, but well, from a company standpoint, that you're not going to get sued. I don't know if it's promising in building culture and stuff like that, but we're not really here to talk about that. There's lots of podcasts that will talk about that, and we're just going to focus on the legal issue. But
before we get to this, I want to jump in. I love the other comments. Ask your boss how you can be her favorite too.
Yeah,
hey, I notice you're being you're giving favoritism to Julie as he or she rolls his eyes or her eyes. But hey, how can I be your favorite? Like,
yeah, I don't.
Sorry, that to me is the worst. That's the worst comment.
You're candy. If you want to be my favorite at work, just ply me with candy. Twix. I'm a really big Twix fan. Anything.
Wait, left or right? Left or right?
Oh, left or right Twix, you mean?
Yeah.
I'm an animal. I just eat them.
I don't even take them out of the wrapper. I just destroy them.
I just crush them in the wrapper and just pour them in my mouth like a snack. But anyway, so again, a lot of the stuff that she's talking about is very feelingsy, which is attorneys we don't really like to deal with, except in employment cases once we have grounds for a discrimination case. Then we want to know about your feelings. But sorry, gotta interrupt you again. I'm sorry, this is great podcasting. I interrupt. There's another comment that says, from just an outside perspective, you seem like an emotional person. This isn't a bad thing, but if your boss isn't, you won't mesh and you definitely not communicate effectively with each other. That, I think, hits it dead on from what we're talking about right now. Yeah, absolutely. And again, it's as a person, if you're the one experiencing favoritism, you really have to ask yourself, what is the basis of this favoritism? And is it just that the other person is better at their job than you are? A lot of what they're saying seems a little bit unreasonable, except when you get to the other part, when we talk about the racism issue, which is something that every company kind of dreads to have to deal with, because it's such a loaded issue in the United States, and can lead to a lot of bad press for a company. Getting accused of racism, of course, is really the kind of worst thing that could happen for a company, in the sense of legal exposure and bad press. So let's talk a little bit about that. Ryan, if now you're not just dealing with the favoritism issue and the HR lead comes to you in your position as a consultant or general counsel, What are you saying when you hear that the person thinks they might be treated differently because of their race?
Yeah, the second part, as we prophetically opined earlier, was the second part of this is a much bigger issue and a much more serious issue, both I think from your side and the employer's side here. If I receive this from an employer, or if I was the employer, or if I was in HR, we'd have to conduct an immediate investigation. I think that it would be improper to advise not to, and to give this any sort of short shrift. Now, it obviously calls into account a lot more, and it's going to be way more involved to perform this kind of investigation. And you're going to have to talk to not only the HR lead, this person, but also Julie. You're going to have to talk to Julie about it. It's going to be very awkward. And the other thing that is kind of going to suck for this employee is nothing's going to get better, like personality wise, between the HR lead, Julie, and this person, because clearly you're complaining about them, and everybody's going to know about it with this investigation. But again, for the company's perspective, got to do it. Lots of problems, lots of big problems here. Not only do you have color protection that you're dealing with, at least under federal law, in California and most states, I think all states, and then you have national origin, and then you have this favoritism issue. I don't know. There's a lot of bad stuff here, and the first thing is immediate investigation, serious investigation.
Well, it's a lot of bad stuff, and it's going to affect the other people in the office, because now these people are, and by these people I mean Julie and the supervisor, are potentially going to become very defensive. As we were talking about, nobody wants to be accused of being racist. It's a very serious thing to be accused of being racist, and some people, if somebody was characterizing your work friendship as being based on being racist against other employees, that's something that is going to be very hard to hear, hard to take, and you're going to feel like the investigation is unfair, and that you're being targeted now. So now you have not only one disgruntled employee as the original complainer, but you have the other two as well. And that could lead to potential legal exposure as well. So, these things are all very, very difficult to deal with. And as we said, sometimes there's no way to get out of these types of things, that somebody is going to sue because they're emotional, and there's nothing you can do as a company, because you cannot micromanage to the level or degree that you could stop these things from happening.
Yeah, and from a plaintiff's attorney perspective, are you salivating at the mouth when you saw the second part, where you had all of these issues to deal with and potential actual grounds for a lawsuit, especially like in a state like California?
Yeah, definitely. As a plaintiff's attorney, I'm really perking up when I hear the second part. Again, not to sound cynical or not to be accused of being cynical, but again, this is all about money. We're suing because we want to get money, and we only want to sue when we can get a considerable amount of money from the company, and that's going to take something that's going to make a jury react emotionally and want to punish the company, and something like racial discrimination is something that juries really become emotional about, and will really punish a company for.
Yeah, especially in a city county like Los Angeles that is extremely diverse. What you're going to have a lot of issues with the jury, given it's most likely going to be diverse. So if you're an employer discriminating based on race, color, national origin, those kind of things, with a diverse jury, you're going to have a bad time.
Yeah, and this is a good foundation for a lawsuit, but then again, you really have to talk to the potential client to see what was the kind of manifestation of this discrimination at work. Here we have somebody, the original poster, who's complaining about the other person being able to come and go as they want, Julie in the office, and being friends with the HR head. And so those things, that's really a fine line for whether or not something racist has gone on, and if this was going to be a good lawsuit. I mean, at this point, with the facts that we know, I'm not.
Well, hold on a second. Don't take the case yet, or don't deny the case yet. Let me add some facts here. So let's assume, because otherwise, I think we're both kind of in a weird, like, abeyance position where we don't really know what to do. Let's assume a couple things. One is company does nothing about it, whether or not there's an investigation and it turns out there's nothing done, or they give short shrift or whatever. Assume that nothing is done. The employee is left at status quo. The manager, or the HR manager, and Julie both know about it, and we fast forward in time to a place where we're kind of left now. This mini bomb or rocket has gone off. investigation conducted, we're back to status quo, and this person comes to you and says, hey, what do I have? What do I have legal remedy wise?
Well, if you don't do anything, if the company doesn't do anything about it, that's something that could be further evidence, or maybe not evidence, but it could definitely suggest that they don't care, and that it could be racist because they didn't take it seriously. As a plaintiff's attorney, you're trying to find advantages in anything the company is doing and reacting. And so an underreaction to something like this is something that's going to make the case a lot more palatable to take on as a plaintiff's attorney, because now you have somebody who has, possibly a very valid complaint. You're going to have to talk to the plaintiff here and or potential plaintiff here, potential client, and see if they're believable, if they're being overly emotional, and how they're going to play with the jury, if people will believe them. Those are all very important things. And let's say you cross that threshold, then you have a company that is negligent in their duty to investigate serious allegations. And that is going to put the company in a bad spot, especially during depositions. This is, even if you don't necessarily have a case that's jumping out at you with facts that suggest racism, once you get the HR person or Julie or whoever into a deposition, now all bets are off. You can, a skilled plaintiff's attorney could really ask questions in a way to put them on a spot that will suggest that the company behaved in a way that would cause them to want to have to settle this case, or that they would be able to be characterized as a company that discriminates based on race.
Yeah, and then trying to jumping into like the litigation part of it, if the employer doesn't have a good file on the employee, and whether or not there's a termination, maybe there's an adverse employment action where they avoid a promotion because of this lack of performance that they're not being given, which under California law, we have our adverse employment action as a condition precedent to a lot of our claims here, employment-based claims here. And if you don't have a file, we hit on this earlier, if you don't have a file on this employee, note to file, you don't have PIP, you don't have, signed handbooks, you don't have whatever, you're gonna have a really, really bad time defending that in the litigation, even if the actions on the employer's side weren't necessarily unlawful. Now, again, you're in front of a jury. In a lot of counties we practice in, they're very diverse, which is amazing, but for this claim for the employer, it's not. So this is a good reminder to the employers out there and HR professionals out there to always maintain files, always make notes. If you're having a problem with an employee, document it, whether it's from a note to file, the smallest possible note where nobody really knows about it, as long as it's in there, all the way up to through discipline and performance improvement plans. You want to make sure you have those documents, because again, if you're sued, that's the first thing they're going to request, if not before. Because in California, there's a way to request the files before pursuant to the code. Again, you're gonna have a very bad time. I don't know where that's from, but I like the quote. You're gonna have a bad time.
That is from South Park. That's the pizza French fries where they're learning how to ski. And if you French fry when you're supposed to pizza,
you're gonna have a bad time.
There you go.
Shout out to South Park, to Matt and Trey.
Exactly, oh, man. And all the money that they've made from their media, which is the plan here. We're probably going to be on Comedy Central within the next few months based on the performance of our first 4 podcasts that have been uploaded. We are up to 96 downloads, people. We are 4 downloads away from being 100 downloads certified. And we know some of you people have just been listening to like the first 4 seconds and turning it off. Honestly, I don't have a problem with it.
That's the best part. You're in the intro. Okay, we're out.
Yeah, as long as we get our stats up, then I'm happy. I don't really care about anything else rather than numbers. So
I don't know about you, but I got my contract from Comedy Central already, and it says if you sign this, just don't come near us, please. Just don't come near us.
Mine probably got lost in the mail or something like that. But yeah, thank you so much for listening. We just want to give a shout out. So everybody, thank you so much. I make light, but we do appreciate it, because we hope we can make some sort of positive impact on your relations with your employees and give you a little bit of guidance. And to that end, I think we should talk about a little about what it looks like to get sued, and you mentioned that there are some ways in the code in California to get employee records before suing, and I think it would be a good time maybe to transition to talk about the demand letter versus the summons and complaint, because they're two very different things that could potentially lead to the same place, which is settlement or the case going away or going to trial, but starting out in very different ways. Ryan, do you want to quickly talk about the difference between getting served with a demand letter and getting served with the summons and complaint?
Yeah. The first, I guess, natural progression and what we're seeing a lot of times, COVID changed a little bit because things went from straight demand letter to lawsuit, but the natural course or natural progression of how an employment lawsuit is received by an employer or its counsel is you receive a demand letter. And usually that first, there's either one or two. The first demand, in the one situation, there's a very detailed, again, the more detailed from the plaintiff's attorney, the better, because the employer is more apt to look into it, respond, and possibly settle early. But you receive a demand letter saying, look, this is all the things that happen. These are all the things that happen. We know they happened. We have proof, whatever. A lot of BS in those letters are very, very long-winded, like artist vocabulary, and they ask for a crap ton of money. And then they say, well, we're entitled to do this crap ton of money, but we'll settle for some lower amount of money, which is still absurd.
Or we'll go to mediation.
Right, or go to mediation. That's the screw you, pay us, or we're going to sue you letter, which happens all across the spectrum of big firms, little firms, and good claims to bad claims. Then you have the second way of doing it, which is the first letter you receive from a plaintiff's attorney, or sometimes from the employee, him or herself, is, hey, I want my file. And the file portion of it, in California specifically, you require an employer, when they receive a demand for the file, they have to produce it within 30 days under Labor Code section 1198.5. If they don't, there's a $750 fine or penalty that employee can receive through litigation, plus attorney's fees and costs to get to that point. I pause and hesitate because the $750 fee is a little ridiculous. To get that $750 fee, the employee has to sue the employer, prevail at trial, and then file a later motion for fees and costs on that one issue. Now, $750 is not a lot of money to an employer when you're talking about spending, $50,000 to $100,000 in defense costs for a very basic case. So a lot of times employers just don't respond because by not responding, I'm going behind the curtain on the defense litigation here.
This is actually huge. This is something a lot of people don't know, and something that's developed since COVID and is a corollary of the fact that cases that used to take maybe a year to get to trial, which put a lot of pressure on the defense counsel when they were dealing with a very responsible and proactive plaintiff's counsel, was that you don't have a lot of time. And with COVID, all these cases got pushed back. Courts went from having an average of, say, 500 cases per judge per courtroom to about 900. And this has really made it difficult for people to get a trial within even 2 years.
Yeah, no, that's a very good point. And to add kind of to that is, if the employer doesn't provide the records to the employee's attorney, like you, if I don't send you out of the employer's records, you're not going to have any confirmation or any documents to support, no, or not to support the claim or to discredit the claim from the employer. So you're stuck, literally stuck with what your client provided you and his or her or otherwise testimony, and that's it. But if the employer provides a file, then obviously they're reducing a cause of action under 1198.5, but they're giving they're supposed to be giving all of the employee file, which in California is very vague, but at a minimum, everything that the employee signed, to the employee's attorney. And what is that employee's attorney going to do? They're incentivized to find something in there to sue you for, right? So that's the first step. That's the first step of demand in this two-phase process. The second step being a follow-up letter from the attorney, essentially saying, thank you, we received the file or not. Here's our demand letter, which is very long-winded, and they want, some crazy amount of money, and we'll go to mediation or we'll settle with you for some smaller amount of money. So really the difference is the first demand for the employee records under 1198.5 pursuant to the labor code, various labor code sections, including section 432, and possibly for wage records, depending on what that employee may believe is wrong.
And just to be clear, even though you've gotten a demand letter and not a complaint, you still need to talk to your attorney about this. It's still something that you need to bring to your attorney. Usually in situations outside of employment, if somebody gets a demand letter, I'll usually tell the client, just ignore it. It doesn't have any legal effect. Don't worry about it until you actually get sued. Because talking to the other side, you might give up stuff that you don't want to give up, information, or just start a dialogue that you can't get out of. And honestly, it's a good strategy in non-employment cases, I would say, to ignore demand letters until you get something serious going.
Well, because that forces them to, what is this? What's the saying? Crap or get off the pot. Like it forces the employer to do something, and it forces the employee to do something. Forces the employee's attorney to really take a stand on: do I trust my client? Is my client going to testify well in front of a jury? Do I believe the client's facts? I mean, all of those things. And am I going to put 2 years of my work out for this person based on their, what they're saying and their lack of documents?
That's a great point, because that was the next thing that I was going to talk about. Is some people might be wondering further a little bit, why would you send a demand letter versus just going ahead and suing? There's a few reasons. Number one, it costs $500 to file the lawsuit. And if you're a plaintiff's attorney, you're usually doing this on contingency, which means that you're going to be paying the costs a lot of times. I mean, depending on the client, but a lot of times you're paying the costs for the lawsuit, and that's going to cost you $500. And not only that, a lot of times the things that the employer is talking about needs to be proven. You need to see what kind of company you're dealing with to see if they're going to be a big problem to sue, or if they're very disorganized and it's going to be a company that is basically shooting themselves in the foot with the way that they run their HR department. And
Right.
so you as a plaintiff's attorney, want to investigate things a little bit further and talk to opposing counsel or the HR department for the company to see if you can see if what your client has been, or potential client has been, saying is true about what happened at that company. So it gives you a little bit more leeway than if you're filing a lawsuit, which is a lot more serious. If you file a lawsuit, then it's one of those things that you really have to go through with. I get a lot of clients that also say, "Oh, just file the lawsuit and we'll see how it goes. And if they don't want to settle, we'll just draw it." Well, it's not that easy just to do that. That's kind of very uninformed way of going about it. So the demand letter just gives you an opportunity to investigate a little bit further without being tied down by the lawsuit and all the formal constraints that are now set on you because you're in a lawsuit, versus sending a demand letter and going to mediation without having a lawsuit filed.
Well, and just kind of to illustrate this point, that was very well said. To illustrate this point, though, let's apply what you just said to this last segment's example. This person comes in and tells you that there is favoritism, that there's this, that there's that, and then they also kind of pepper in there the color, national origin, race potential issues. I mean, that to me is a wobbler. Is that, well, they spent a lot of time in their example talking about how they just weren't happy with the favoritism with no concrete examples. But then again, they said a lot of buzzwords at the end, discrimination, race, not from here, possibly color, because you said they're not, or they said they're color of color. So, I mean, there's a lot there. I mean, I would think from a plaintiff's attorney perspective, if you weren't sure you're taking the case, didn't have concrete examples, didn't have like, oh yeah, we got this employer, they're screwed, they screwed something up. You're going to need that demand. You're going to need to try to verify some of these claims, because again, 2 years of a plaintiff's attorney's life on the IFCOM, I think they call it, and the cool kids call it, is a lot of work and a lot of risk, which I think you'd want to avoid. Which again, I'm sorry, go ahead.
Oh no, I was just going to say, we talked a little bit earlier about how difficult it is for the representatives of the company to be caught in a deposition, but just as much for the plaintiff as well, because I've had situations where the plaintiff is sitting in a deposition where they've claimed discrimination, they've claimed harassment, and then when they're asked straight up, what is this lawsuit about? I think we might have mentioned this before, but they'll say something like, "Oh, I just want to get paid for my back injury," and that's one of those things that will just sink a case immediately. And so if you don't have a lot of confidence in your client, you're not going to want to go ahead and move forward with a lawsuit.
Yep, agreed. And that, again, not to keep saying highlighted these examples, but that highlights the reason why an employer would not want to respond to the demand letter. Yes, there's a penalty. Yes, there's a potential you're going to get sued for not providing, and on that basis only, and going to trial and losing and spending all this money. But there's also a better chance that an attorney's not going to take that case, and that they can't take the case, or they won't take the case because they don't have any confirmation from their client that anything actually happened. They're just sitting there with some amount of facts that they cannot verify or discredit, and they're just not comfortable taking it forward. And that's a big, I'm not saying that any employer should not comply with the law. They absolutely should. And it's always our advice from at least my office to comply with every single law they're required to, every demand letter, everything. I can't force them to do that. I'm an attorney. I'm not an enforcer. I'm not in the mafia that I can talk about. So it's one of those things where, you know, all you can do is sit there. But strategically, litigation strategy is, you know, you're taking a lot of balls out of this this pitching machine to give to the attorney on the other side to sue the employer if you don't provide that file.
Yeah, absolutely. It becomes very difficult as a plaintiff's attorney to want to commit to something like that when you don't have a lot of information, because one of the things that's very helpful, especially if you don't have a smoking gun email that says something racist or a recording or something of that nature, kind of hard evidence, which a lot of times these cases lack, is witnesses. And a company that has good culture, that does investigations, that takes things seriously, is going to have employees that respect the culture and not lining up to be a witness in a case against the company. So that's why it's kind of very important to have this good culture in place, because if you do get sued, you want to make sure that it's by a rogue actor and it's not just a representative of a class of employees who have been feeling this way. Because if it is that, one lawsuit can really trigger a whole bunch of other lawsuits, or a whole bunch of people coming out of the woodwork with similar claims, and that could really be damaging to a company.
Yeah, agreed. And that's another reason to keep things in arbitration, which is the subject of another conversation for a future podcast. Did you? So I don't want to like step on where you're at here on this stuff, but this might be a good time to talk about instead of like, you know, the lawsuit route. We've kind of addressed how that would start from this employee from our example earlier, but maybe to talk a little bit about making sure your HR department and your company is complying, first doing their jobs, but then complying with internal policy.
Yeah, absolutely. I think we can break here. We're going to end segment 2, give our sponsors another chance to get in your ear and tell you about their great products and great services that they have. And we'll be right back. And we're back with segment 3. Segment 3 is called "We Scare the Shit Out of You," also known as "This is Why You Need an Arbitration Clause." We're still working on the name thing. This is brought to you by our sponsors. Of course, we'd like to give a big shout out to our sponsors who make this podcast possible. Our first sponsor is Ryan Ellis Law Corporation, very generous sponsor who has I don't know, what did they?
I don't know these people. I just heard they're great. I don't know what they. You take all the money. I just talk. I don't know what they paid. I just know they're good people, and you should patronize their business and/or services.
Yeah, thanks to Ryan Ellis Law Corp. I'm off to Wingstop after this. And then also our other wonderful sponsor, Law Office of Arda Wildeboer, who has generous.
Also great people. I've never met them, never heard of them, but a little bit less great than the Ryan Ellis people I've heard.
Yeah, I just talked to them on the phone, you know, when they wanted to sponsor us. So that's the only reason I know. Okay, so in this wonderful segment, we want to talk about huge jury verdicts that have happened here in California that should scare any employer. And the first one that we want to talk about is a $464 million verdict that was here in LA Superior Court, where a jury awarded 2 employees of, I think it was LA County, for a case that dealt with sexual harassment, racial harassment in the workplace, and wrongful termination.
I don't even know what to say to this. I mean, 464 million. Full disclosure, I've not read the verdict. I have not checked the appeal process. I would venture to bet. I would bet. Venture to bet. I would bet a lot of money.
Yes.
Venture to guess. I venture to guess that this has been appealed, probably in the annals of the appellate process. But oh my goodness, I could not imagine being a plaintiff or a plaintiff's attorney and getting in Los Angeles County, so state court, a $464 million verdict. 440 of that being punitive. I mean, there have to be facts here that are just absurd. I mean, this is, I'm in shock. This is exactly what you have to have as a plaintiff's attorney to kind of advertise, hey, I'm so good. But on the employer side, like when you're firing your attorney, I would assume. But, and again, I don't know who did it. I'm sure there's basis and all that stuff. But oh my goodness. And from the defense side, like you said, Arda, to use my word, highlight arbitration clause, valid, enforceable arbitration clause.
Yeah, this is the only thing you can do really to combat getting to this point. I think arbitration clause, there's something that California has tried to target to take out of employee contracts. And I think there's even a little bit more momentum on the federal side to get rid of these things, because they really put employees in a very tough position, because arbitration famously, I think, really awards maybe, I think 17% on average of what jury verdicts are. So that's a huge amount of difference between going to arbitration and going to a jury. Arbitrators in employment cases are paid directly by the defendants, by the employers, because the law says that the employees don't have to pay anything over and above what they would have to pay to file a lawsuit, which is in California about $500. It's a good thing for the employees in the sense that they only have to pay $500, but now they're in a forum which is less likely to reward them for damages in the same way that a jury would, or the threat of a jury would. So you would probably get a higher settlement if you're in court and settle before trial. Whereas, you know, if you're in arbitration and you want to settle during the mediation before the arbitration starts, you're probably going to settle for a lot less, because there's a lot less potential damages to be awarded in arbitration.
Yeah, and so a little bit more about this case. It was in Los Angeles. It was jury verdict, yes. It was brought by two men who alleged they were forced, who alleged they were forced out of their jobs at Southern California Edison. And this is after they complained about repeated sexual and racial harassment in one of the offices. I think it's interesting because this is a sexual harassment case brought by a male, which is, I'm not going to say atypical, but for a verdict this size, I would not have guessed it was a male, or two males in this situation. There's two plaintiffs. And one of the plaintiffs alleged that after being at Edison for 16 years, he was pushed out of a supervisor job constructively, saying that Southern California Edison created and permitted an intolerable working condition to force him out after he reported widespread harassment and racist language. I mean, this to me screams of large verdict, but this also screams to me, prove it. Right? I mean, there's no way that you can get this kind of money without showing some blatant and patently bad harassment and racist things going on inside the company.
Listen, you're not even gonna get $100,000 as a plaintiff if you can't prove that, let alone 464 million. There's 22 and change in compensatory damages, and then the rest being punitive damages. I mean, that is just a punishment for behavior that has to be absolutely insanely egregious. And usually that deals with retaliation, that deals with the company covering up things, botched investigations, wrongfully terminating the employees that complain. These are the types of things that companies do that really will expose them to lawsuits after hearing complaints from employees. But I can't even really wrap my head around $400,000 or $400 million in a situation like this. But again, the lesson here is have an arbitration clause and do things the right way. And Ryan, what are some of the things that you can do if you're dealing with this to mitigate the ability for plaintiffs' attorneys to get damages against you?
No, great question. And in one of the attorney's comments, one of the plaintiff's attorney's comments said that these two men had the courage to stand up to the harassment and discrimination or racist comments, and that the company's response was to pretend the problem was limited to a handful of bad actors, ignoring the culture of the company. This goes directly to what we were talking about earlier about having an employee handbook, asterisk, asterisk, name of the podcast, asterisk, asterisk. But at the same time, having enforcement of your policies, making sure that you address complaints properly, making sure that you don't short shrift anything. I use that phrase a few times in this episode, and giving really everybody the response of, hey, we're taking this under consideration. We're going to conduct a fair and thorough investigation and provide a response, discipline, or other action based on, hopefully objectively, based on the facts that we have and what we find in our investigation. Clearly, Southern California Edison didn't do that. Otherwise, the jury wouldn't have awarded such ridiculous numbers. And again, I say ridiculous, jealous that it's not going to my bank account, but it's just ridiculously high. So at the same time, really, this is like one of the 440 million prime examples of why it's very important for company, I guess, HR department, company employees, C-suite, not only to have a handbook, but to comply with the policies and procedures, and especially in California, comply with law, which is do not discriminate, do not retaliate, do not discriminate, retaliate, do not harass, take this stuff seriously, perform an investigation. If you something of this magnitude, I would think that SCE would have hired an outside investigator or outside HR company to conduct an objective investigation. And again, I don't know the facts. I don't know all the facts, just making kind of comments based on the articles we've read here. But this to me is something that just hits to the real foundation of what we talk about in this podcast, which is have an employee handbook, have your employees do their job, hold them accountable, make sure you have your files set, and don't, essentially don't allow for that to happen beyond the point of like an HR department running all these investigations when there could be bigger implications at issue. Definitely get counsel involved.
And I think there's a fear from a lot of companies that if they conduct an investigation, they are paying credence to the complaints. And if they conduct an investigation, that somehow is going to be evidence that something has gone wrong, and maybe make other employees aware of the situation and create some exposure for the company, which, I mean, I guess it could be true that conducting an investigation, it's kind of like, well, I can't really think of the metaphor, but anyway, it's kind of just, they don't want to whip people up into a frenzy. They don't want to get the idea of suing the company into people's heads at all. And so they won't do an investigation because they think if they ignore it, or if they do like a botched investigation, these employees will go away and they won't reach the complaint stage. But one thing I have to say about that is we talk about the emotional response driving people wanting to sue. And if you do these types of things, what you're doing is really guaranteeing that there's going to be an emotional response here to the people that are bringing up these complaints, and then either being ignored or feeling that like the company is kind of circling the wagons and creating a story or a narrative that really dismisses their complaints and puts them in a worse position than they were before they complained.
Yeah, and that's the rough dichotomy between what HR people think and want to do and what they think is going to happen versus what the law says. California, and again, I don't have the federal law in front of me, so I'm not going to quote it. I deal mostly in California employment cases as defense counsel. In California, you have an affirmative duty to prevent and correct unlawful behavior pursuant to the law. So if you do not investigate, you are not meeting your duty, period. I'm not saying that's the law, because a jury could find otherwise, but somebody like ARDA, competent counsel, will hammer you, which I'm sure counsel that we're in the case we're talking about did. That's hence the verdict. But if you don't investigate, you don't do it properly, you don't do a full and complete investigation, you're gonna have a bad time. You're gonna have a bad time. You're gonna have a $460 million bad time. But just essentially do the job, do the work. You're there to do a job. Don't have favoritism. Get through the investigation. Comply with the law. No investigation equals no compliance with your policies or the law, if you have policies, which you should. Again, employee handbook. And make sure you comply with those. If you don't, you're gonna have a really bad time.
Well, here's the thing. Even if you do all those things right, and we talked about, there's no way to stop getting sued. There's nothing to do from completely stopping getting sued. But if they would have done all those things correctly, this is something that they might have settled for $75,000 in mediation and never would have gotten out. Instead, they're now dealing with the specter of a $464 million verdict hanging over their head, even though it's likely to get reduced on appeal. It doesn't matter. The impact on a company of having a verdict like that brought against them, even an institutional sized company like Southern California Edison, that's just a huge dramatic impact that will take years to recover from. But one thing about these investigations is that it's not necessarily the HR department who's responsible for not wanting to do these investigations. And a lot of times you have HR departments that really know what their responsibility is to their employees and want to do it, but then they have an issue with the C-suite people who don't necessarily want to act on the information given to them or the advice given to them by the HR department. And Ryan, this is probably something that you deal with a lot in your position consulting, is companies that don't want to listen to your advice. They pay for it and they know you're the expert, but then they don't want to act on it. So HR departments deal with that a lot too. What would you say to an HR person that is getting a lot of either pushback from the C-suite, or the C-suite just won't listen to that?
Yeah, and you phrased the question very well, because from an HR department, your job is to direct and advise. You can't tell the C-suite what to do if you're simply in an HR managerial role without decision-making authority. You're a hey, I did the research, here's what we have, here's what counsel says, here's your list of options, like pick one. C-suite doesn't do it, they don't do it. There's an example of a client of mine ex-client of mine, previous client of mine, whatever, who received a result from a third-party company discussing internal issues in the company. Those policies and suggestions from the third party that conducted the audit or conducted the research were not followed, and that led to a significant litigation after the fact, which could have completely been prevented if the company made the right decision. And again, I'm not saying the company made the wrong decision. I'm not saying that they weren't completely followed. I'm not throwing a company under the bus here at all. But this is 464 million reasons as to why the C-suite needs to really give suggestions from the HR department full consideration, given potential issues in litigation. And again, just to kind of circle back to your question, HR department, anybody minus a decision-making C-suite HR person, you just got to direct and you got to provide advice and provide options. In situations like this, speak up, make sure your voice is heard. Because again, you won't be held liable because you're not making the decision, but at the same time, you want to make sure you're doing your job.
I think it's a very difficult position to be in as an HR person, because it's not like you can go to the employees and announce like, hey, listen, I tried, but these jerks up there at the CEO's office don't want to do what I'm telling them to do. You can't do that. And you're in the unenviable position at this point of having to carry out policies that have been decided upon by your superiors that you don't agree with. And that's a very difficult position to be in. And I think, again, that's why the relationship between managers and employees is so important, for managers to be able to explain these decisions and not just leave it on HR. Because again, so many of these things are dumped on the HR department that they're not supposed to be dealing with.
This is all, sorry, I'm sorry. Bad habit. So this is another reason to have general counsel or even have a law firm on retainer to provide these questions to. Hey, we have this, insert issue here. Can you provide your comments? Or, hey, we have this issue here. I have prepared a memorandum for you about what I believe our choices are. Can you vet it for me? Because, an HR professional can have their signature on a memo with options to the C-suite or up to management, but that's probably not going to be given as much credibility, which despite the fact that it should be, not given as much credibility as the same memorandum that's been blessed by counsel. So again, it's just trying to, the bigger the decision, the bigger the issue, obviously use more, try to get more research and consent to that, to not persuade C-suite, because again, you're just presenting options, but direct in the right way to help them make the right decision. And again, in this set of facts, obviously this decision or whatever the investigation was an issue from the start. That goes to a whole company culture issue, that goes to holding people accountable issue, that goes to, strength of management issue. There's so many things to talk about as to what went wrong in the beginning, which maybe is a good subject for to going back and fixing and reverse engineering cases to see how it could have been prevented, kind of like the butterfly effect.
Yeah.
But you know, one of those things where you can't do that. I mean, you can't look back or look forward and see what's going to happen, but you can definitely look back. And if you don't, another, again, the phrase, if you don't acknowledge history or understand history, it's doomed to repeat itself. Something like that, where if you don't do that, you're screwed. And this is a prime example. I don't know if I answered the question. That kind of went off there. My bad.
No, it's a good point you make, because this is, of course, this is the answer to what's the worst that could happen. If you wanted to know what's the worst that could happen from running your company in a shitty way, here you go. That's it. I mean, it doesn't even have to be 464 or $424 million company. It could be a lot less. But again, this is the answer to what's the worst that could happen. So we want people to be very cognizant of the fact that a lot of these things seem like they'll go away or they're not a big deal, but they could be. You know, it's like the reverse lottery. You're in it to lose it, and you never know when your number is going to be called.
Mm-hmm.
So, let me see. What do we got here? I think we're around an hour here. I think maybe we could wrap things up. We want to thank our sponsors again, Ryan Ellis Law Corporation, for their generous sponsorship. Arda Wildeboer, his office, law office of Arda Wildeboer, you know, generously sponsoring this show as well, and paying for ads on LinkedIn to draw all you wonderful people here.
Well, so, I'm going to take the glass half full approach and say we thank you for being here this long on this podcast and staying tuned in. If you have any thoughts or comments, questions, concerns, podcast ideas, let us know. We're always open. Although we have our kind of topics we want to talk about, you know, we want to hear from you. Heard from a couple of you already, mostly my family members, but it's okay. They're subscribers.
We know there's around 98 people or 96 people who are listening to this thing. So, you know, somebody, if you have types of suggestion, we love you. We'd love to hear your suggestions. Hi, Mom. How are you? Hopefully, Mom, you've listened this far.
Yeah, and on that note, thank you all very much. We look forward to seeing you in our next episode, where we talk about something that you're going to want to hear.
Yeah, absolutely. That you know, is very important.
Yeah, that one or two things.
Yeah, 3 minutes before we start the show next. That's the end of the show.
Thanks, everybody.